Why do we keep talking about intellectual property right, or IPR, like it's the ultimate key to innovation? On paper, the idea seems so simple: protect creators, reward the hard work, and keep the wheels of innovation turning. Sound great, right? But here's the catch: what happens when the system meant to foster progress starts holding it back? Think about it. The truth is, IBR isn't just about who owns what, it's about power, assets, and the stories we keep telling ourselves about innovation. And sometimes those stories don't really match the reality. So, what's going on? Are the very laws designed to encourage progress actually making it harder for people to innovate? Today, we're diving into how current IBR practice can hinder innovation by exploring the two real-world examples in case one and case two. Here's the overview of today our presentation. Now, we start with Jung.
Okay, hello everyone. My name is Trung, and this is my part. So, to better understand about the topic, I will give you to the case of ST25 rice. This is the world best rice variety developed by Mr. Ho and Kuo. And when ST25 rice was successfully developed and commercialized in both domestic and international markets, some foreign companies, particularly in Australia and the US, quickly register for ownership of the rice variety in their countries. So this was impossible because SD25 rice had not been registered for brand copyright protection. So Mr. Core filed a lawsuit to reclaim his right, but the court, based on the IPR regulation, declared that ST25 is a rice variety and the name of the plant variety cannot be trademarked. So making copyright registration in this situation is invalid. So to illustrate this issue, imagine this. If a company successfully register for AC-certified rice copyright in the US, Vietnam would be forced to export the right through that company, and or they can be faced with the intellectual property infringement penalties. And in addition, learning from the ST25 rights case, I believe that the current intellectual property rights practice are not the main cause in the innovation, but the main causes in this industry are the lack of awareness of intellectual property and the lack of anticipation of ST25 success and the complicated trademark registration residues and lack of support from authorities. So we can raise the question here: why didn't the business provide more robust protection and support from the beginning? So, based on the research, the SD25 research team mainly comprised with the scientists and agriculture engineers who excel at uh, research and developing crops. They may lack experience in commercializing product, building brand, protecting them from the market. In addition, the rapid success of SD25 in the market may also lead to the complacency within the research team, preventing them from taking timely and comprehensive brand protection measures. So, when asked about this issue, a representative from Ministry of Industry and Trade affirmed that the primary responsibility lies with the business. It is their intellectual property. So, from the business responsibilities perspective, we can conclude that the lack of national protection and support for AC25 resulted from combination of factors including awareness, experience, resources, support, and industry-specific characteristic. So therefore, there is a need for government agency to provide more support and collaborate closely to the businesses. So to more understand about the government agency and the support, now I will invite Lam to talk about these issues.
Moreover, we strongly believe that government has responsibilities uh, with these problems also. So, quoted from the professor and Dr. Võ Tong Xuân, an expert in rice and plant, that the fact that four businesses in the U.S. registered the world's best rice brand ST-25 of Vietnam since July 2020 is the fault of Mr. Hồ Quang Của, but also the fault of Vietnamese authorities. So yeah, that is true because in 2019, when ST-25 has gained public attention when winning the world's best rice award in the Philippines, no action has been done from Hồ Quang Của and also the Vietnamese authorities. Mr. Hồ Quang Của didn't register for the trademark, and Vietnamese the Ministry Agriculture and Rural Development, he hasn't recognized this variety because it has not been tested domestically, which will result that there are no promotions for Mr. Hồ Quang Của, and there will be no supports like rights for Mr. Hồ Quang Của to plant this variety of rice in large scales. So the fact that government has not much of interest in propagating and helping firms in branding and trademark that leads to the consequences. And in order to gain back the brand, government has to file a lawsuit against those four companies, which which will cause us a complex level of paperwork, time, and millions of dollars just to prove that Mr. Hồ Quang Của is the founding fathers of ST-25. One other aspect that needs to be mentioned here is that the government policies in applications for IPR are costly and sophisticated. That's why many Vietnamese authors they have no interest in applying for trademark, and ST-25 struggles to apply for a trademark is the perfect examples which shows the weakness in IPR in Vietnam. And this story has been a problem for Vietnamese lawmakers for decades. And plenty of similar problems has happened before, such as Phú Quốc fish sauce and Trung Nguyên coffee and so on.
So let me present another case showing evidence that current intellectual property rights practices hinder innovation during the COVID-19 pandemic. The extremely successful mRNA COVID-19 vaccine developers, including Pfizer, BioNTech, and Moderna, have recently been under criticism for not sharing their vaccination formulas with other producers. So this case highlights the conflict between intellectual property rights, business objectives, and global public health requirements, presenting ongoing concern about how to balance innovative incentives with fair access during public health emergencies. The intellectual property rights IPR hinder innovation in the COVID-19 vaccine case by preventing collaboration, slowing vaccine development and production, and also restricting access to necessary technology and knowledge. So the mRNA vaccination technology used by Pfizer, BioNTech, and Moderna was developed through publicly supported research. However, these businesses had patents on certain formulations and delivery techniques, preventing others from using or developing these technologies without permissions. So the lack of knowledge sharing has facilitated unequal worldwide vaccine distribution. Critics said that this approach hindered efforts to contain the epidemic globally and create disparity in medical care. As a result, other researchers and manufacturers were unable to create alternate or improved versions of mRNA vaccination. So this monopoly on vital technology hindered worldwide innovation, especially in variant-specific or next-generation vaccination. For example, the emergence of variations such as Delta or Omicron require adjustment to vaccination formulations. Countries such as South Africa, India, and Brazil could produce mRNA vaccines if they had access to the technology, because local manufacturers could have resulted in improvement compatible with tropical regions or single-dose formulations. Due to lack of access, these nations remain consumer rather than contributor to mRNA innovation. In this case, it is more complicated than the ST25 right case before due to the complexity of the pharmaceutical and vaccine industries.
Greetings, everyone. I will now talk about the complexity of IPR, intellectual property rules in pharmaceutical industry. The IPR were meant to help protect creators from having their works from being exploited by others. But during the worldwide pandemic, there are problems with vaccine equities that make a vaccine couldn't be distributed fairly to many countries that needed them. These problems are much more complicated than the case of ST25 rights, since the pharmaceutical industry and the political policy can be very hard to navigate and work with. A prime example is that in the pharmaceutical industry, uh, uh, they are afraid of a decrease in research and development, the R&D, since they would have to waive their patents. This could deter them from launching new lines of vaccine and even other medicine research during and even after the pandemic. Additionally, in the political policies, some developed countries like Canada, for example, have said that they would send vaccine to developing countries to help them through this pandemic. And yet, not only did they hardly send any vaccine at the beginning, they also hold much of the vaccine more than they could have used for their people. And when they started to send vaccine out, analysis saw again that there's a certain amount of discrimination from them towards certain developing countries that have suffered from colonialism, which represented them in a bad light in aspect regarding healthcare and stability. These problems and behaviors had caused needless suffering for people who could have been saved if it weren't for the complex and multi-layered nature of the IPR in the pharmaceutical industry as well as in the political worldview of policies. There should be some way to form a balanced approach for fair compensation for vaccine developers while also facilitating broader access to vaccine, a way so that IPR doesn't hinder innovation and the equities of access to medicine and vaccine.
At the end of the day, the effectiveness of IBR practices isn't a one-size-fits-all solution. It's shaped by the unique complexities of each industry. In fields like agriculture, where innovation tends to be more discrete and less intertwined, things like new crops varieties or traditional farming techniques, the current IBR system often delivers solid results. But in more intricate landscapes like technology or pharmaceuticals, where innovation are deeply interconnected and build on each other, the cracks in the system start to show. At its core, IBR creates space for ideas to grow, and that responsibility rests not only with governments or corporations, but with everyone. Moreover, as the work becomes faster and more complex, IBR practices must evolve to keep up as well. Here are some recommendations for improving the current IBR practice system. The first one, we could increase awareness and accessibility for everyone by providing easy to understand resources and training on IBR basics for the small businesses and startups. And moreover, we could offer subsidies or to simplify filing processes to encourage IBR adoption in the underrepresented areas. And second recommendation is to adapt IBR for AI and digital innovations by updating copyright laws to recognize and regulate AI generated content, or introducing frameworks for non-traditional IBR like NFTs and virtual goods in the metaverse in the future as well. So that's the end of our quick presentation. Thanks for listening.